So if we can just move on, probably a couple of slides, Jen. Let's skirt past the photo one, yeah, and the next one, lovely. So today we're looking at NEC 4. So this is the second of our series this year. Last year we looked at NEC generally. So I thought it would be useful to cover the NEC 4 contract and specifically what changes have been made to it as compared to NEC 3. I suspect you probably some of you may be kind of completely into NEC 4 now, but if not, you're probably seeing them coming through. Certainly, we're not seeing any NEC 3 contracts being submitted in new projects. So what are we going to cover? There's a lot of slides on this. I went to town a little bit. So what I'm aiming to do is to get through about the first half, which covers everything. And then the second half just deals with the process. So the procedure for dealing with all the items that we'll have covered. If you're familiar with NEC, you'll sort of get the drift with them all. It's very much a process-driven contract. So there are clauses, you know, who submits what, when, what are the time limits, etc. So we probably won't get that covered, but hopefully it'll be of use, you know, later on if you get the slides. So we're going to look at the new contracts that NEC issued. We're going to look at the financial elements that have changed, always important. Also, we're going to look at dispute resolution clauses, not necessarily because they are important, but you know, hopefully not too well used, but more because this is where the changes are. And there are some quite useful changes. And we're also going to look at those Z clauses and how they've changed. The contract was introduced 2017 and then some amendments were made in 2019, so we'll look at those. And then, as I've just said, there are the procedures, but we probably won't have chance to cover those, albeit in the first section when I'm talking about it, we will talk roughly about the procedures. Just note the point at the end of the slides where I'm talking about a contractor. I'm also meaning a subcontractor in a subcontract. So it's, you know, the party who is applying to be paid, typically, you know, the party doing the work, as opposed to the party paying for it. So just bear that in mind. If I'm talking about contractors, I'm also referring to you if you're a subcontractor. And I suppose the same applies to clients or employers. If I'm talking about them, I'm also talking about the contractor in a subcontract. So if we can have the next slide, please, Jen. Yeah, and the next slide. So that's just to say that NEC's used all over the world. So the history, and we looked at this last month, relatively recent contract compared to JCT, which is circa 1930s. NEC started off in 1993 and it was very much, it was called the new engineering contract. And that was very much the focus, engineering. It was then changed by NEC2 in 1995, and that was when the one that we kind of tend to use became the ECC, the Engineering and Construction Contract. So it sort of it widened its ambit. A couple of new contracts added: PSC, Professional Services Contract for those design consultants, and also the adjudication contract. NEC3 came out in 2005. Probably the version you're working on is the amended version, which was 2013, brought in substantially to deal with the changes that we had to the Housing Grants, Construction and Regeneration Act in 2011. Two new contracts added to that. The term service contracts are very similar to the ECC, but ECC is for a specific project, a build project. Term service is for doing certain specific works over a specific period of time rather than to a specific project. And also the FC, the framework contract. And often they're used in conjunction with each other, the TSC and the framework contract. So then NEC4 came out in 2017. As we've seen, it's been amended slightly, just very slightly. 2 new contracts, the DBO, Design, Build and Operate, and also the Alliance contract, both introduced. So if we can have the next slide, please. So before we look at those 2 new contracts, the terminology throughout's changed very slightly. You'll see not a huge number of changes, but generally, I think they're helpful. So right-hand side, we've got NEC3, where we refer to the employer. In NEC4, you can see it's now changed to the client, which to me, it's more user-friendly. Client is, what we talk about rather than employer. So again, at NEC3, we've got the WI, the works information. In NEC4, we have the scope of works. Again, it's just more more what you would expect. We all know what a scope of work is. If you're not familiar with NEC, you wouldn't necessarily know what works information was all about. So 2 good changes there. Third one, it's gender neutral. Also, the fourth one, NEC3 introduced the risk register, which is what it says it is. It's a register of risk. It's now been changed to the early warning register to tie in with your early warning notices. I think this is a good change because I remember when the risk register was introduced in NEC3, having several instances where contractors and subcontractors had included a risk register it was in the contract, and in some cases their understanding was that if the risk was in the risk register, it meant that it was the employer stroke client's risk, which wasn't the case. And in some cases, subcontractors had tried to reallocate the risk in the risk register. And again, it's not great because it's not then crystal clear. So for example, you put weather in the risk register, even if in the risk register and it's appended to the contract, you say, this is client's risk, you've still got a compensation event that only awards time and money to the contractor in regard to weather in certain weather circumstances. So you ended up with a bit of a sort of ambiguity in the contract. So hopefully that won't happen now that it's been renamed. And also just a point there with regard to the early warning register, it's the project manager's responsibility to issue the first one, and it's got to be done within 1 week of the starting date. Next slide, please, Jen. So the design, build and operate. I've not seen any of these contracts. I suspect they're not being used substantially, but also it is going to be fairly rare that they are used because, as it says in the first bullet point, it is what it says it is. It's a design and build contract, but also it's the operate element as well. So I don't know what, that would be, I don't know, 5 years, 10 years, 20 years. So quite an unusual construction contract to have all of it. So to an extent, a little bit academic for the purpose of this seminar, but good to know, that it exists. Another couple of points. So it's basically a combination of the ECC, the engineering and construction contract. That's the sort of build bit, and of course, we can make the ECC into a design and build contract, and the TSC, the term service contract, is the operate element. And as we are used to with NEC, the clauses flow through. It's all, fairly standard, just with some particular changes to deal with this particular scenario. Where I think it might be helpful is the third bullet point, because reasonable skill and care is a standard clause, so in those core clauses, whereas in the ECC, it's an X optional clause, it's X15. So why I think it's useful is that if you are negotiating your ECC contract and you have design, and the client is saying they will not include X15 as an option, which means that the design liability would be fitness for purpose. And we know that, we don't like that. The insurers won't cover it, etc. What you can do is say, well, look, there's this DBO contract, design and build, reasonable skill and care is the norm. That shows that it should be the norm in the ECC if there is design. And it's only optional because the idea behind the ECC is that you might not have any design, in which case it's not needed. And actually the same argument goes with regard to the professional services contract. Reasonable skill and care is in the core clauses. Again, PII, professional indemnity insurance, to cover the design liability, to reasonable skill and care only, of course, is included, as is copyright. So it's kind of converting the ECC. Next slide, please. So the next slide, I think, yes, the alliance contracts. This is the second contract introduced. I think this will be even more rarely used. So, it's going to be very, very rare to use this. So the alliance element of it is it's kind of it's an odd concept. If you are very used to the concept of the contract chain, where client contracts with employer, employer with subcontractor, etc., etc. Because this contract is a contract that everybody signs, or the client signs, the contractor signs, the main subcontractors, the main design consultants. And it's the aim is, as it says in the third bullet point, one team, one budget. So a huge amount of collaboration, very little scope for extras. So very, very limited in terms of compensation events. You can adjudicate, but of course, it's not, as it says there at the bottom, not really in the spirit of the alliance contract. And the innovative thing is that it's one insurance, it's a project insurance, so include professional indemnity, etc. So kind of quite different to what we're used to. We did start to have similar contracts kind of 2010-ish, but then in the global recession, they seemed to sort of disappear. So they never really got off the ground. So we'll see in the next few years what happens with regard to them now that they are in the NEC. Next slide, please. So I like to talk about the guidance notes. So NEC3, we've got 158 pages of guidance notes, which to me says must have something important to say in there. And I use them quite a lot. Sometimes it's just saying what you interpret the clause as. Sometimes it's quite helpful. The NEC4, they've divided it into 4 separate volumes, as you can see on the slide. So number 1, procurement. Number 2, preparing an engineering and construction contract. Number 3, selecting a supplier. And number 4, managing the contract. So there's a lot there. The first 3, are obviously the sort of front end of the works. The fourth one is interpreting the contract from a project perspective, from a project that's ongoing. Next slide, please. Okay, so turning to the specific changes. So we've got four kind of financial changes, and this is the first one. So it's in that first set of core clauses, clause 16. So if you remember, we sort of start, strange numbering, we start with clause 10. So this is the first section of the core clauses. And what it is contractors' proposals for cost savings. So I've put there the first point, will it be used? And I say that because it substantially requires the parties to agree things. So yes, it might be used if the project's going well, but if it's not going so well, it might not be. So what would happen would be the contractor, might think, well, if we change the scope, so remember that's the works information, we make changes to the scope, we could save some money. And how it works is that if the project manager accepts the proposal, then it's submitted as a compensation event. And the savings between the parties are shared. So how is that done? That's the only bit that's the kind of new bit. Well, not the new bit, but how would that work? Well, the savings are set out in the contract data part 1. So the default positions, that's the 5th slide down. The default position is the savings will be 50-50, but obviously that can be adjusted when the contract's been negotiated. So, if you're a contractor or a subcontractor and you're thinking when you're tendering for work, oh, we might be able to find some cost savings here, think about whether the 50-50 works for you or whether you'd want it adjusting. So the PM doesn't have to accept the proposal for obvious reasons. It's the client's project. If they want to pay more, if they want to pay the contract price rather than making a saving, that's entirely up to them. And with options C and D, which are the target cost, then the savings come through in the target cost. So effectively, the savings are dealt with in the pain gain share when that's determined. So that's the first one. So if we can have the next slide, please. And this is the second financial one. So again, contractor's proposal, and this time it's for cost savings to the lifetime cost of the project. It's not in the core clauses, it's clause X21, so it's an optional clause. So again, if you're tendering for work and you're thinking, oh, we might be able to make some cost savings on the lifetime cost, first of all, you need to make sure X21 is included, and then you need to think about, what it actually involves. So again, will it be used and will it work? This is slightly different because whilst the savings are shared, it's not a compensation event. The whole thing has to be agreed between the parties. So it's the savings have to be agreed because it's slightly different here. What are the savings for the lifetime cost? Because essentially, I suspect contractor would be saying, if you pay more for the build, we can use different materials or different methodologies, which will mean that the maintenance is cheaper, the materials last longer, so you don't need to, repair them or replace them as often. So the savings, need to be agreed. That's going to be quite tricky to agree, the savings over the lifetime of a building. And also how those savings are to be shared would have to be agreed. There's no percentage in the contract data for that. So I think there are a few hurdles. Typically, when I've spoken to civil engineers, they're not keen on this. They kind of generally say to me that they can't really see, that there are that many opportunities for savings on the lifetime cost. The M&E contractors often can think of things that they could suggest. So yeah, just want to bear in mind. So the next slide. So this is the third financial element, and this is finalising the defined costs. So it only applies to options C, D, E and F. So C and D are the target cost contracts, E and F reimbursable, and the management contract doesn't apply to your fixed price costs contracts A and B, and you'll see why. So this is basically, as it says, second bullet point, a procedure to agree the final amount due under the contract. So it's a line in the sand as regards defined costs for a particular piece of work that's been finalised. So typically, it might be, halfway through the project, certain parts of the work have been completed. There's always a risk that the project manager will deduct costs from it if they find that something's wrong or they recalculate. So it's the contractor's opportunity to say, PM, can you please check this, and let's try and do a line in the sand, agree that the defined cost, for that piece of work that we've finished is agreed. My view, and I don't want to sound too negative, I'm just trying to give the pros and cons here. The fourth bullet point, once that has been done, the project manager has 13 weeks in which to consider and respond. So my view is that that's only going to happen on relatively large projects. If you've got a 20-week project, you're not going to do it. If you've got a 40-week project, bearing in mind you've got to finish, a chunk of the work before you can apply for it. Again, it's probably not going to really work, really be worth the effort. Once it is agreed, then it's pretty much set in stone, except that the parties can challenge it by reference to dispute resolution. So that would be generally to adjudication. Next slide, please. And this is the final cost item, which if you're falling asleep, listen to this bit and then fall asleep. So this is I think for me, this is the most important change, and it has possible benefits for contractors and subcontractors, but also some possible risks. And it's the finality of the account at clause 53. And it's one example of where JCT and NEC are very, very gradually sort of adopting what each other do. And in this case, NEC is adopting what has been in JCT for years, but isn't well known about, and that is a provision that the final account can become conclusive between the parties if one party submits the final account and the other one doesn't object to it, and also act on that objection within certain timescales. So be careful with your JCT, because this is going to alert people to the JCT provisions as well, but also be careful of it in NEC 4. So how it works is, second bullet point here, at the end of your defects period, so typically that'd be 12 months, excuse me, a defect certificate will be issued. And then within 4 weeks of that defect certificate, the project manager is required to issue a final assessment of the contractor's account. So basically a final account. Probably if it's an acceptable figure, if contractor or subcontractor and a subcontractor is happy with it, there's no problem. The issue arises where a big delta has arisen through the project, and the PM certifies what it considers due, typically a lower figure, and the contractor thinks that it's entitled to substantially more. So bear that in mind. Project manager issues the final assessment, but it's got to be done within 4 weeks of the defect certificate. So that's the risk to contractors and subcontractors. The opportunity is the next bullet point down, the penultimate bullet point. If the PM fails to issue the final assessment in that timescale, the contractor can issue its own final assessment. And obviously it then issues it in the sums that it considers should be paid. So if we can have the next slide, please. And we'll see why this is important. So it's important because that final assessment, doesn't matter who's issued it, but the final assessment becomes conclusive to the other party, well, to both parties really, but as to the sum due. So, if you're the contractor issuing the final assessment, make sure you put the right figure in, the figure that you think your account is worth. It becomes conclusive unless, so you can see the sub bullet point. The first one is it's referred to the senior representatives within 4 weeks of that final assessment. And then it's referred to adjudication within 3 weeks of the senior representatives agreement. Now, there's also a provision, this slide's not quite right. You can also go straight to adjudication. So that first bullet, sub-bullet where it says it's referred to senior reps within 4 weeks of the final assessment, you can also refer it to you can refer it to adjudication within 4 weeks. The final sub-bullet point's not really relevant for this stage. This is, it refers to once you've got your adjudicator's award, you've then got only 4 weeks to refer the matter to the tribunal, which is court or arbitration, very different to adjudication, but you've got to do it. So the account becomes final and conclusive unless those steps are complied with. So that's an opportunity if the contractor has submitted the final assessment, because the onus is on the client to start one of those processes. And if they don't, then it's final and conclusive. But it's a risk for the contractor if the project manager submits the final assessment and the contractor doesn't take any of those steps, because it will be deemed to have accepted the account in the sum valued by the project manager. So just be really careful of this. What you really need to be doing is basically thinking, when you get completion, hurrah, you get some of your attention back, great news, leave site, etc., move on to the next project. But think about how long is this defects period? I would be thinking, right, well, halfway through, let's see where we are in sorting out the final assessment, the final account. If we've still got that huge delta, we might want to go and get some legal advice just to check that, we're all okay. So that's halfway through your defects period, but also be aware, and, hopefully you've had your legal advice, and just to check that, these timescales haven't been amended, how long it might take to prep if you need to go to dispute resolution. I would think what you want to be doing is ramping up and getting an adjudication started rather than waiting for these deadlines. But how the deadlines will work is, as soon as you get the end of your defects period, you need to be thinking, right, 4 weeks. It might, of course, be less because the period might be reduced in a Z clause, but 4 weeks to get your defects certificate, and then you've only got 4 weeks in which time you've got to do something, either refer to the senior reps or have an adjudication. The one thing about adjudication is you get a real tactical advantage if you have prepared in advance. So it's not a great scenario, unless it's a really small adjudication, to think, right, well, we've got that certificate. I've got 4 weeks to start an adjudication. I'll contact my lawyers in 2 weeks' time and they can get it done in a week or so. They'll do it because that's what we do. But, it won't be such a good product. And of course, the whole advantage of adjudication is if you're starting the process, you've got that time to really produce a good, clear document, to really clearly explain to the adjudicator what the claim's about, make it really simple for the adjudicator to find in your favour. So don't don't kind of tie your own hands behind your back by leaving it too late. Next slide, please. And the next slide. Just a couple of notes on that point. All right, I said, yes, so this is another point, just a really small point on the financial side. So this is interim payment applications, really minor change. In NEC 3, it says that the contractor, the party wanting to be paid, may submit its interim payment application on or prior to the assessment date. It now says you must do it. So I suspect that project managers will say, well, if you must do it and you don't do it, then we have no obligation to make an assessment. So, you know, as it says there in the second bullet point, why wouldn't the contractor or subcontractor submit an interim payment application? But just be careful that you do. Next slide, please. A couple of new compensation events. Don't get too excited because they're not earth-shattering. The first one, 60.120, so it's the 20th compensation event, plus a few actually elsewhere in the contract. And we do have a seminar probably about February or March where we look at all the compensation events and the processes. So new compensation event 20, where the contractor gets paid for preparing a quote for a proposed instruction. So it's going to be really, really limited. In my experience, proposed instructions are quite rare, and it's just for preparing the quote for it. So it's not going to be huge amounts of money. A proposed instruction is where the PM and the client say, you know, we're thinking we might change the scope, we might do something different. Can you price it? What kind of price is it going to be? But it's very clear, you know, it's a proposed instruction, so you're not being instructed to do anything different at this stage. They want to see what the price is and the time implication before they instruct it. So, you know, as I say, in my experience, rarely used. And then the other one, number 21, is just that the additional CEs, compensation events, can be put in the contract data part 1. Contract data part 1 is the part that the client completes, and it's the bit is right at the end. Generally speaking, clients don't add new compensation events to benefit contractors and subcontractors unless the contractor stroke subcontractor specifically requires it. Usually it's more likely that the existing CEs will be changed and modified. So in January, we've got a webinar on Z clauses where the clauses are modified. But what we're seeing a lot of, for example, at the moment, is changes to the compensation events to subdivide them in the way that JCT does. So with some items in JCT, you might get an extension of time, but you might not be entitled to loss and expense. And that's what we're seeing in terms of amending compensation events. By way of example, I'm not keen on this 21 because we already have Z clauses where compensation events can be added, they can be changed, and they are. So from my perspective, it just means that when contractors, subcontractors are reviewing contracts, reviewing invitations to tender, reviewing a contract, if, you know, a dispute's arising, there's just, you know, another place in the contract that you have to check to make sure that, you know, there aren't any new CEs or the old CEs haven't been changed. But that's where we are. Next slide, please. Okay, so the schedule of cost components and fee. So the schedule of cost components is used in a variety of different ways. Again, probably about March, April, we've got a separate session on the schedule of cost components in detail. The key bit here, this is sort of a little introduction to it. So it's basically how to get paid, except in a fixed price contract, so options A and B, where the schedule of cost components, more accurate, the shorter schedule applies with regard to compensation events only. But the fourth bullet point, covers all the elements of these schedules. So they're just what you'd expect: people, equipment, plant and materials, charges. So that's your kind of electricity, lighting, some, miscellaneous costs, the third party statutory fees, um, off-site manufacture, off-site design, and insurance. That's not the cost of insurance, it's dealing with insurance claims. So if you're interested in all that, come to the seminar that we're doing on that. But if we can move to the next slide, because I just want to cover the changes that have been made. So some things have been removed, some things have been added to these schedules. So the things that have been removed. So the first thing is that for options C, D, and E, we only now have the schedule of cost components. In NEC3, there is the option for the parties to use the shorter schedule if they want for a particular CE. In my experience, it's never used, and I suspect that's why it's been removed. In reality, on a CE by CE basis, there is nothing to stop the parties still saying, shall we use that shorter schedule of cost components? It's still actually in the contract, it's just not being used. But the norm is it's been removed for options C, D, and E. Also removed is the working areas. This is the second bullet point and then the second sub-bullet. We had working areas overhead and people overheads. They both covered similar things, but were for different contracts, A, B, C, D, and D. And very, very simply, they were percentages that went into the contract dated part 2, which is completed by the contractor or subcontractor. For things like the electric used on site, some things like small tools, so kind of relatively low cost items. I think this isn't particularly helpful because I think it just makes it easy if you've got a percentage figure to use for small cost items. Now you've got to prove your cost, which is fine if it's substantial amounts, but if it's small amounts, it's probably going to be quite difficult. Also, the design overhead percentage has been removed. So it just means that the rates, it needs to be included as a one rate for a designer. I think that, it's definitely simpler. And there is a bit of a move towards rates in NEC, which for those of you who've operated NEC for a while will recognize that that really simplifies things. Conversely, of course, the situation that we're in now with high inflation, um, fixed rates are not helpful for that, particularly on long-term projects, because who knows where we're going to be with inflation next year. But the way things are, certainly with people, is that salaries etc are increasing, so you might find that you have fixed rates for people but you're still having to increase their salaries throughout the project. Also, we've deleted the subcontractor fee. Brilliant news. And if we can move to the next slide, it'll become apparent why. And that's because in NEC3, if you're not familiar with it, you'll have noticed in the kind of shopping list of items that we had that covered that schedule, there wasn't anything that covered subcontractors, and that's because they were covered by way of the defined cost. They've now been removed from the definition of defined cost and they are in the schedule of cost components. It's a relatively small change, but I think it's really helpful because again, it puts everything in one place. rather than having, subcontractors in, the definitions section in under defined cost, and the rest of the schedule, the rest of the cost items under the schedule. Next, a bullet point for options A and B, so our fixed price contracts where the schedules are relevant to how you price compensation events. So really shouldn't be massively important, but that depends on how many compensation events there are. There's an option to, well, no, it's been changed actually, it's not an option. It's been changed so that instead of having to prove the cost of individual people on site, there's a provision for rates to be included for disciplines of people, which again, I think makes it more efficient, but of course the inflation point applies. And also finally, if you're used to using other forms of contract, the schedule of cost components has also been added to the PSC, the professional services contract, term service contract and the subcontracts. Next slide, please. So what I would say generally is I think they're all really helpful changes on the whole. So next I want to look at dispute resolution. So this first one should have probably named this slightly different. So we're assuming that we're on W2, which typically you will be. These are projects where the Housing Grants Act applies. W1 is the alternative, and that applies to projects abroad, because our Acts of Parliament, Housing Grants Act included, don't apply abroad, and also to some projects where the Housing Grants Act in this country doesn't apply. So some water sewage treatment works, some food processing works, pharmaceuticals. There are some exceptions to the Housing Grants Act. Assuming it does apply, what we now have is a senior representatives process. So this is one of the all the items that we've looked at so far are part of those processes in the slides at the end, but this is as well. If we can just move to the next slide, Jen. So this covers the process very briefly, but it's in a bit more detail in the slides at the end that we won't cover. So the senior representatives are named in the contract date as part 1, part 2. So there's a bit, part 1, client fills in their senior representatives. I think there's an option to put 2 names. Part 2, contractor puts their senior representatives. So again, when you're reviewing a contract, you should be thinking about this. Who has the other party put down? Because you need somebody senior. You'd want a director, someone high level who has the authority to make decisions to reach a settlement if a dispute arises. And ditto, for the contract data part 2. Also, you want people who haven't really been involved in the project, so don't have that emotional attachment to it, so hopefully they can look at it, in the cool light of day and, try and reach a commercial agreement if there is a dispute. So that's the first 2 bullet points. So what's the process? It's pretty simple, to be honest, and relatively flexible. Either party, if a dispute arises, can refer the matter to the senior representatives. They just email the other party as well as all of the senior representatives, and then that both parties have a week to make a submission. So that would be a written submission. And then the senior reps have 3 weeks to investigate and make a decision. And within those 3 weeks, between them, they can pretty much do what they want. They can go and visit site. They could ask people to make submissions to them in person. They can ask questions. The contractor's senior rep can ask the contractor private questions behind the scenes. So there's all sorts, but the idea is that the senior reps from each party at some point come together and try and reach some consensus. They don't need to agree everything, but they might be able to agree something. So for example, you know, if it's a compensation event, they might agree, yes, it's a compensation event, but no, we can't agree the quantum. Or yes, it's a compensation event and we can agree, you know, it's 3 weeks delay, so 3 weeks extra time, but we can't agree the you know, so it's very, very flexible. So the next slide, please. And just so that you're aware, that that process can be carried out. It doesn't replace adjudication, but if you want to, you can run it before adjudication. Um, but you don't have to, so you can go straight to adjudication if you want. I mean, probably, potentially, there's nothing to stop you running it after adjudication if you're not happy with the award. But you know, the chances are you're not going to get much progress there. But you know, it's not unheard of. Dispute avoidance board, I'm not going to cover this in any detail. It's W3, so we've now got a new W clause. But it's basically aimed at projects where the Housing Grants Act doesn't apply. So as an alternative to adjudication. It's probably only going to be relevant to big disputes. All the dispute avoidance board does is make a recommendation to the parties. It's not like going to court or adjudication where a decision is made one way or the other. It's a recommendation and one or both parties can reject it and it doesn't then, you know, it doesn't become binding. Next slide, please. So this next slide deals with the, you know, how you get there. So the board is made up of 3 members. So each party would appoint one, and then the two members then appoint the third. So typically the type of people who might be appointed would be somebody like, I suspect a lot of the people who are adjudicators will, you know, offer their services as, you know, members of dispute avoidance boards. So basically construction professionals and lawyers, barristers, solicitors who are not a party to the project, so they will typically be independent. So this one isn't for, you know, a director of the contractor and a director of the client. The problem with this, and this is why I say it'll probably only work and apply with bigger projects, is that the idea is that the board, the 3 members, are involved in the project throughout, so that if something comes up, they can very quickly be brought in to, you know, make suggestions. But of course, that means both parties are having to pay these third parties. They're unlikely to do it, you know, out of the goodness of their hearts. So you know, it's going to be a fairly costly exercise, and I suspect on most projects, people would probably just prefer to go to adjudication, pay the cost, but at least you're guaranteed some sort of result. Of course, you can't do that if you're not entitled to adjudicate, which is where this is aimed at. But you know, it might have some success. We will see as time goes on. Next slide, please. And the next slide. Okay, so we've got some changes to the X clauses. Some of it is terminology, some of it is extras added. So we've got an option clause X8, and this is called undertaking to client or other, which, you know, at first glance I just thought, what's that about? Well, it's basically collateral warranties. And I think actually, just another little plug, in the November seminar is about collateral warranties and other protection given to the paying party under NEC. So this is about collateral warranties basically. The form of the warranty should be appended to the contract data part 1. And it's just the process with regard to that. So the next slide, please. So the next option, X9, so transfer of rights. Again, what does that mean? Well, it's basically copyright. So the usual, a license to use contractors' copyright. Next slide, please. X10, we've got some BIM provisions. Not going to go into this in detail, but as you would expect in NEC, it's quite process driven, and an execution plan is required. That's the third bullet point. And then an information model is required also. So that's the fourth bullet point. So next option. So do bear in mind as well that, these are optional clauses. So, you need to check when you're reviewing your contract, are they included or not? Do you particularly want them? Are you going to negotiate them in or out? Depending. So yeah, if we can have the next slide, please. X11, termination at will by the client. So note that termination at will is basically where contract hasn't done anything wrong, so it's only the client who can use this clause, and it's where, for example, the client could decide they can get the work done cheaper by someone else. They might be thinking, we don't want to progress this project for some reason. But fundamentally, there are other clauses in the contract if the contractor has done something wrong. Now, what you might find that is that, if clients kind of unhappy with things, wants to get somebody else on board, they'll use this clause rather than the default termination provisions, just because this one's easy to use. You don't need, or not you, the client doesn't need to show that the contractor's done anything wrong. All the client needs to say is, I want to terminate the contract. Now, it's actually already in NEC3 at clause 90.2. It's just that lots of parties don't really know. It's sort of a little bit hidden. So, watch out for it. My view would be to try and get it negotiated out if it's in, because the whole ethos of construction contracts is once they're signed, the contractor has to do the work. As you'll be aware, if you're not happy, you can't refuse to do compensation events. If you don't want to do the extra work, you've still got to do it. If the price can't be agreed, you can't down tools and wait for the price to be agreed. You've got to keep on and do the work. If it's disputed, it's a compensation event. The contractor has to keep going with the work, can't suspend, generally speaking, can't walk away unless there are grounds in the contract that it can comply with. So, and there's good reason. It's a sort of construction project is, a long-term, relationship very often. Construction works typically aren't completed in, a matter of a few days. So fundamentally, it doesn't seem very fair that the client can just terminate the contract just like that. However, what the clause says is that if they do that, the contractor can recover its fee percentage, so it's loss of profit and overhead, and also any commitments that it can't get out of, that it's entered into in anticipation of carrying out the works. So should be able to recover most of its losses, albeit, it's then going to have to find, a new project to move its people onto. The other thing that I would say is beware of those Z clauses amending this. So where option 11 is included, so client can terminate at will, but then the clause allowing that compensation to be paid is removed and limited, because then contractors in the worst of both worlds lost the project and not at all compensated. Next slide, please. Very quickly, so this is multi-party collaboration. It used to be called partnering. The next slide, please. X15, this has been in throughout. So this is the contractor's design, that reasonable skill and care option that we talked about earlier. It now includes a requirement for professional indemnity insurance. I suspect what you will continue to see is that removed. And actually, what I'm seeing at the moment a lot of is that whole provision not being included, but Z clauses, so bespoke amendments, providing for reasonable skill and care and the insurance. But you just need to make sure that one or the other is in. Next slide, please. X16 retention, we've always had retention, unfortunately, for contractors and subcontractors. The only change here is that it provides for a retention bond if the parties agree to it. And the next slide, please. X22, again, it's optional and it's two-stage early contractor involvement. So the way I sort of think about it is the second stage is basically your engineering and construction contract work, you kind of standard construction work. It's the stage one bit that's different. And it's different because you are being paid effectively to do things like finalize the design, bring on board the main subcontractors, liaise with the design consultants, do ground investigations. So the idea is that we avoid the problem situations that I often see where clients in a real rush to get started pushes the contractor to start. Sometimes the contract hasn't been properly agreed, the price hasn't been sorted properly, sometimes the ground investigations are a bit sketchy, etc, 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 and the project, starts to go awry very quickly, and results in extra cost and a dispute between the parties. So really good in principle. Let's see whether it's used or not. But basically, through that stage one, the contractor, there's a system of sort of mini forecasting your costs, so pretty much on a weekly basis. What's my cost going to be this next week? Yeah, that's what I will, that's my payment application, so that the client has a real really good grip of what the costing is in that first stage. Next slide, please. And then the next slide. Oh, the program, just one very small change here. My preference is that the program is incorporated into the contract. If it isn't, contractor or subcontractor has to submit the program once it's started, and the project manager then has to accept or reject it. Big problems, because if it's rejected, I've seen whole projects go from start to finish without having an accepted program, causes a big problem with regard to compensation events vis-a-vis the extension of time, but generally, which is why I like to have the program in the contract. This change, excuse me, means that if the contractor submits the program, it's not included in the contract, contractor submits it after the works have started and the project manager doesn't respond. So doesn't respond to accept or reject it. What it means there is you've got a program, but it's not an accepted program. So it's no good from an NEC perspective. So the new provision at 31.3 allows the contractor to write to the project manager a default notice, basically saying, you've not accepted or rejected our program within the timescales. Forgot what the timescale is. I think it's 2 weeks. So you've not accepted or rejected within 2 weeks. We're giving you 1 more week. So this is the third bullet point. And if you don't respond and if the PM doesn't respond within that week, they are deemed to have accepted it. So you've got your accepted programme and you can go through the project on that basis. So valuable, albeit that you've got to think, it's not a good start to the project, is it? The PM's not looking particularly lively if they don't respond the first time and then fail to respond with the default notice as well. But it's helpful in trying to ensure that you get an accepted programme. Next slide, please. Just skip over that. It's relatively minor. And we'll skip over that. And that one, I think. Yeah, I think there are just some changes to the termination provisions, but they're just the 2019 amendments, they're pretty minor. And I think the next slide is 2019. Right, so this is onto the procedures thing that I talked about initially. So I'm going to stop there because I've gone over a little bit already, so I apologise for that. The rest of this, you'll see, we've already talked about the senior representatives, if you remember. This is just setting out the procedure in a little bit more detail. It's pretty deep, it's covered in the contract anyway, but you might find that looking at the slides, is a bit easier than reading the contract. Obviously do both, and obviously think about whether there are any Z clauses as well, which we always have to do. But I'm going to finish it there. Happy to deal with any questions. And as I say, apologies for going over a little bit.
No worries, Sarah. Thank you very much. I'm sure everyone's found that really beneficial. I will, as I mentioned at the beginning of the webinar, I will send the slides out, so you will be able to take a look at the slides in your own time. There has been no questions in the chat, Sarah. But if anybody does have any questions, if you want to reply to me on email, or you'll likely have access to Sarah's email address on the slides. So please feel free if there is anything that you think of on reflection. In terms of next month's webinar, the day is sort of a week earlier in the month. So the webinar is going to take place on Tuesday the 14th at the same time, and that's covering collateral warranties and other employer protection. And then we have the seminar to the webinar taking place on the Thursday that week. So that's the 16th. And that's a breakfast seminar in the morning at the Bridge Hotel and Spa in Wetherby. And like I said last month, we do strongly recommend where you can to attend face-to-face. So we'll leave it there for today, guys. But thank you very much, Sarah. And thanks everyone for joining. See you next month.